Here. Thank you. And I will have Commissioner Brady lead us in the Pledge of Allegiance, please.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And just a few house cleaning matters. As we always tell you, the First District Court of Appeals has kindly allowed us to use their facility. So please let's respect their rules and have absolutely no food or beverages other than water in this room. Please silence your cell phones, and any person addressing the commission, please speak up so our recording equipment can pick you up properly. I also ask that everyone be as succinct as you can in your questions, comments, so that we can get through the agenda as efficiently as possible. And along similar lines, please, everyone wait to be recognized by the chair before speaking. Also, pursuant to Section 286.0114 of the Florida statutes, members of the public have the opportunity to have input on proposals before the commission, other than in cases in which we act in a quasi-judicial capacity. This means that the public can have input on matters other than complaints, opinions, and determinations on financial disclosure cases. If you desire to be heard on a matter, please fill out a speaker's card and give to Ms. Fulford. And she is in the back with her hands raised. Yay! Now we come to item 3 on the agenda.
Mr. Chairman,
Yes,
may I be recognized?
sure, certainly.
First off, Mr. Chairman, I'd like to thank you for your service as chair. You've done an incredible job, very even, fair-handed, and a calming influence sometimes on some
Thank you.
contentious discussions that we've had. I would like to move that the most honorable Matt Carlucci become our new chair, and the Honorable Commissioner Ankers to become our vice chair.
Okay, there's a motion on the floor to have Commissioner Carlucci become chair and Commissioner Ankers become vice chair. Is there a second?
Second.
There's a second. Is there any discussion? All in favor?
Aye.
All opposed? So done. But before we move forward, let me just say a few things. It has indeed been my privilege and pleasure to be up here before you and with you doing the business of the state of Florida, the people of the state of Florida. There is no higher calling that we have than be a public servant. And as we know in the climate of today's politics, if you will, it is very difficult for people like us to want to get into the arena because of the constant badgering of Twitter, Facebook, and all the other things that are out there that I don't even know. So, but I want to thank everyone for allowing me to serve as your chair, commissioners. I would like to thank the staff again for the yeoman's work that they always put into this endeavor to make, not only, as I said last night, to make us look good, and you make it look easy for us to do our jobs. And I am will be forever grateful. And as I turn over the mantle to Mr. Carlucci, my friend, that hails from the great state of Florida in the great city of Jacksonville, I can't.
Conventions.
That's right. The time warp. I can't think of someone who I value as a friend who has the passion to do the people's work more than Matt Carlucci. I've known Matt. I was an assistant general counsel with the city of Jacksonville back in the 80s. And I was there from 85, 86 to 1994. During that time, Matt had his hand and his passion in trying to do the right things for what makes Jacksonville great. And he's always been there for Jacksonville. He's always been there for the people that he represented. And I remember when he ran for mayor, and I was there supporting him at the time. And so we go back a long way. And so I can't think of someone who really loves, as I said, doing the people's work, and handing over the gavel to Mr. Carlucci is indeed a good pleasure. And also, he's not only done the work for the city of Jacksonville and its people, but as you know, several years ago, when we were on the precipice of passing legislation, trying to figure out how we would change some of the way we do business and the like, he volunteered to be our liaison with the legislature. And as you know, that's not necessarily an easy task. And he, along with Valindia and the rest of our team, Perry and everyone, really made some good things happen for us. Of course, we can never give everything we want, but we got enough to keep us going in the right direction. And so, as I turn over the gavel, I know that it will be in great hands. And I know that you have more than a show horse in Mr. Carlucci. You have a workhorse. And for that, I will be ever grateful. And also, as he is, believe it or not, term limited from serving with us, we would like to hand him this plaque for his service to the commission for all these number of years. And actually, we started about the same time, if I'm not mistaken.
You're a month ahead.
Anyway, thank you for your service. Well, you want to?
Well, okay. We're, let me see what to do with this. Here, thank you. Well, let's see where we are on the agenda, because we kind of, well, I don't know whether to say goodbye or hello. So Stan echoed so many of my thoughts that I wanted to say as well. First, I want to thank the commission members that I serve with now and the ones that I served with prior for how much I've learned from those past and those here now. I have told so many people this is the finest group of members I've ever served with. But now I have the distinct honor. And it's funny how life takes twists and turns, because you never know where you're going to wind up sometimes. You just don't. I remember Stan and I working together in City Hall. I think it was probably the old City Hall back then. And he was on the 13th floor and I was on the 10th floor, and I would call Stan for help. And you could always get the right answer from Stan Weston. Because when you are elected or appointed to any body, you have to make sure that what you're presenting is sound. And you always got that from Stan. And Stan has great training not only in government, but in the private sector. And Stan and I hit it off immediately. But I always thought he was 15 years younger than me. But Stan's the workhorse. And I got to tell you, I've served with a lot of folks here who've been, or in the past, I guess I should say now, that have chaired this commission, and many of whom I thought did an outstanding job, and not the least of which you have done an outstanding job. I mean, you just put one foot in front of you. You got an orderly mind. You kept us on track so many times when I tried to, I mean, some people tried to veer you off. The other thing that I appreciated from Stan, because he has a sense of fairness. Stan has a sense of fairness, so everybody, nobody ever had their opportunity discouraged from speaking what they thought with our chairman, Chairman Weston. He's very thoughtful in his decision-making. And so I don't know what else to say except you're my friend, and I love you. And I want to give this plaque, and this is probably one of my great moments of my life, to present this to somebody that I have just the highest respect for, and that is Stan Weston, and may you become a judge ASAP. Is this when I can say a few words? Okay. I'd like to introduce my family if I could. Like I said, I'm not sure whether to say goodbye or hello, but first I'll start with my wife, Karen. Stand up, honey. My beautiful wife, Karen. She has been my inspiration for my whole life. When she heard I was going to be on the Commission on Ethics, she just thought, wow. She says, you need to take that right now. And you know, when you go home, you got to have inspiration sometimes, and I have to try to inspire her. I hope I do that. A good job of that, but she inspires me just with her smile in her eyes. That's all it takes. And then I have my son Joseph, my youngest son Joseph. You can stand up with your wife Victoria. Victoria is laden with child as we speak. And then my son Matthew and his beautiful wife Lauren, and they're here to see me say goodbye and hello all at the same time. But I got to tell you, there's nothing greater for those of you who have children that are coming up, that have a family that will follow you, just to watch a little event like this, and it means a lot. And thank you all for being here. So I have to say a few other things. I have to thank Verlindia most of all for all that I've learned from her and the great job she's done for this commission, and to have worked alongside her a few years ago as we went over to Tallahassee lobbying for legislation. I have learned so much. She is fierce in her approach, but I've never heard anybody who could speak before the legislature, even when they're not being nice, and just keep a straight face and a little hint of a smile, and keep her discussion so orderly and so legal. She's an amazing, amazing lady. And again, I've learned so much from the commissioners. It is a great honor. If I don't say anything else, I may not be here next year, so you have to put up with this for just a minute or two. I mean, next year, I don't know how long I'll be here, okay, because I'm term limited out. But to be a part of a commission that is designed by somebody the likes of Ruben Askew, that upholds and is intended to uphold ethical behavior of our public officials. My daddy oftentimes said that his best friends were the ones he didn't agree with very much, but he loved them the most because they were the most honest and they were the most ethical, and he put that as number one. That was the bottom of the pyramid to him. And that is our job, is to try to uphold that to the best of our abilities. So it's been a great honor to be a part of that. And the other thing that Stan alluded to, and then I have to allude to as well, but that is the staff and the advocates. Y'all are the ones, and I wish I could say everybody's name. I just, we get over here every 6 weeks. I'm just not that great with being able to point out the names. But I know what you do. And I know the hard work you put in, particularly when disclosure time comes around. And nobody can understand how many disclosures that they have to review. Thousands. You'd be surprised how many people have to do disclosures. And they review them all. And they call people who are late. And they call. I call it diapering sometimes. But, and the work that they put behind making us look like we're doing a good job, but we could never do it without the staff that we have. And so my hat is off to every staff member and former staff member, I see one in the back there, and for the job that you do. So like I said, I'm a little bit on borrowed time. I hope I haven't left anything out. Fran, thanks for keeping me on time on your emails, wherever Fran's right over there. And but I will give you my very best. That's all I can say. And I thank you for this honor for however long it lasts. And I got a big pair of shoes to fill. So with that said,
They're skinny.
they're skinny. I know they're skinny. Let me just gather myself for a second and see where we're at, and we'll get the meeting begun. Okay, so we're through all that. Oh, yes, okay. You didn't tell me I had to look at three things all at the same time, Stan. I think I can get rid of this one here.
You'll get it quickly.
Yeah. We need to have a motion of approval of the minutes. Is there a motion to approve the minutes of June 3rd,
So moved.
2016? There's a motion and a second. Is there any discussion? All in favor, say aye.
Aye.
Opposed, say no. You have, by your action, approved the minutes of June 3rd, 2016. We have consideration of final action, and on the Michael S. Murphy 15-178, agenda item 5A. Will the parties or their counsel please identify themselves for the record?
Elizabeth Miller, advocate for the commission.
Okay. Do we have the respondent in the audience? No. Okay. This is a case in which the commission was required to initiate an investigation to determine whether a failure to make financial disclosure was willful. It comes to us after the administrative law judge relinquished jurisdiction at DOA because there were no longer any facts in dispute. We have before us a memorandum and draft final order for consideration adopting the matters deemed admitted at DOA, finding the respondent willfully failed to file financial disclosure for the year 2013 and recommending that he be removed from his position as district agent of the Cooperative Producers Water Control District. We will hear from the advocate.
Thank you, Mr. Chairman, Commissioners. Again, I'm Elizabeth Miller, advocate for the commission. Just to give you a brief overview of what posture we're in now, and I will be happy to answer any of your questions as to how we got to this posture. As the district agent for the Cooperative Producers Water Control District, the respondent was required to file his 2013 CE Form 1 Statement of Financial Interest. He did not. After the commission found probable cause, the case was forwarded to the Division of Administrative Hearings so that the respondent could have his day in court. The respondent was offered every opportunity to participate in the process. He did not. The administrative law judge deemed that I had conclusively established the factual and legal case against the respondent because he completely and willfully refused to participate in the discovery process. Now the case was relinquished and it's back before you for the entry of a final order. I am respectfully asking you to make a finding on 5 issues. Specifically, number 1, that another proceeding is not appropriate or necessary in this case because there are no disputed issues of fact or conclusions of law, as they were all resolved at the Division of Administrative Hearings. And the respondent is not entitled to a second bite of the apple. Secondly, that the commission adopt the administrative law judge's May 18, 2016 order granting motion to deem facts admitted and relinquish jurisdiction. Third, that you find a violation of paragraph C, subsection 8, section 112.3145 Florida statutes. Fourth, that you incorporate the administrative law judge's findings of fact and conclusions of law in your final order. And lastly, that you recommend the only penalty established by law for this violation in this case, and that is removal from public office or public employment. The draft of the final order and public report that's before you addresses these 5 issues, and I ask kindly that you adopt it. Thank you. I'll be happy to answer any questions.
Okay, thank you very much. Do we have any questions from the members or a motion? Questions first. Commissioner Weston?
It seems, and correct me if I'm wrong, but this is one of the first orders that has gone up based on the newly enacted statute. And if you can explain that for us. I mean, a number of years ago, this provision wasn't in place. If you don't mind.
That's correct. Yes, sir, I will. This is actually the second order that will go before the governor. The first one, the respondent did not want to challenge it, did not want a DOA hearing, so the final order went to the governor, and he issued his executive order. This is the second one that will go to the governor. This was after a DOA proceeding.
And so this is the first one that went to the full.
Yes, sir.
Okay.
That's correct. Yes, sir.
All right.
Any other questions?
He just didn't show up at all?
That's correct. He didn't participate at all. Although we had many communications, the judge offered him every opportunity to participate. He chose not to.
Commissioner Ankers.
If you'll accept it, I would propose a motion to accept the recommended final order and the findings there.
Okay, we have a motion to accept the order and a second by Commissioner Norris. Is there any discussion on the motion? All in favor say aye.
Aye.
Opposed say no. By your action, you have approved the advocate's posture on the case, and we will move now to the next item on the agenda.
Thank you.
Yes, ma'am. Thank you. The next item is consideration of dismissal Gerald Burwell, 15-120, agenda item 6A. This is a request by the advocate for dismissal in another case arising from the law requiring self-initiation of complaints when officials fail to file financial disclosure. We will now hear from Ms. Hadley, our advocate.
At the time that the commission entered its order finding probable cause, respondent was serving as a member of the Walton County Design Review Board. On or about May 19th of this year, respondent resigned. Because the holding of public office is necessary to invoke and maintain the commission's investigatory jurisdiction under this section, the commission no longer possesses jurisdiction in this matter. Based on the respondent's resignation from office, I ask the commission to dismiss the complaint based on the lack of jurisdiction.
Move for approval.
Second.
Okay, no questions first? We had a motion by Commissioner Cox and a second by Commissioner Ankers, is that correct?
Yes.
Okay, any discussion on the motion? All in favor say aye.
Aye.
Opposed say no. By your action, you have approved the advocate's position. Thank you, Ms. Hadley. Now, we are in the part of our agenda on consideration of advisory opinions. This is where public, elected, private, appointed officials sometimes ask the commission for opinions as to what they can and can't do in their particular office that they hold. And the let me see where we are here. The first advisory opinion is going to be File 2679, gift acceptance and disclosure, valuation of attendance at a charity polo match. And we will hear from, Caroline Clanky.
Thank you, Mr. Chairman. Caroline Clanky, Commission Legal Staff. File number 2679 arose from an inquiry posed by the City Attorney on behalf of the Village of Wellington Council regarding the valuation of tickets to an event for disclosure purposes. In May of 2016, members of the City Council, their spouses, and certain senior staff members were provided with 14 complimentary tickets to a charity polo match featuring Prince Harry of Wales. The polo match was a private invitation-only event. No tickets were available for sale to the public, and all tickets reflected no dollar value. Rather, sponsors seeking to attend the event made charitable contributions directly to Prince Harry's charity, Sentabale, and in exchange received a certain number of tables commensurate with the amount of their charitable contribution. The conference organizer and donor of the tickets, Valiente Polo Club, is neither the principal of lobbyists nor a vendor of the city. The organizer also confirmed that it provided the entirety of funding for the event, including the cost of all food, beverages, transportation, and entertainment. Staff calculated the value of the gift of admission to each individual to be $895. This figure was derived in accordance with the valuation methodology contained in Section 112.31487J Florida statutes by calculating the total cost of all items provided during the event, here $358,000, divided by the 400 guests in attendance at the event. In accordance with the reporting requirements of Section 112.31488A, since the value of each admission to the May 2016 event exceeds $100, each reporting individual who accepted one or more admissions is required to disclose this permissible gift on a CE Form 9 quarterly gift disclosure form on or before the calendar quarter ending September 30th, 2016. This opinion is hereby submitted for your consideration.
Is the requester here Lori Cohen? Is she in attendance?
I do not believe
Okay. Okay. So we have the opinion, the drafted opinion has been presented. Do we have any questions from the members? Okay. Do we have a motion on adoption of the draft opinion?
So moved.
Second.
Motion by Commissioner Brady, a second by Commissioner Cox. Is there any discussion on the motion? All in favor, say aye.
Aye.
Opposed, say no. By your action, you have approved Ms. Clanky's opinion. And then we will now go to file 2681, will be represented by Betsy Daly. Is the requester here on this opinion?
Yes, Mr. Chairman.
Okay, what is your name, sir, and your address?
Joseph Gillespie, 3828 Shamrock Street, West Tallahassee.
Okay. Thank you for being here. I appreciate it, and we all do as well. Okay, Ms. Daly, would you like to present the opinion draft?
Yes, thank you, Mr. Chair. The requester is employed in the legislature. He's the staff director of the House Bill Drafting Service. He asked whether if he were to leave that position, he would be subject to the 2-year representation restriction on lobbying the legislature that is in Section 112.313(9A)(4) of the Florida statutes. The definition of legislative employee in the statute does not include this particular staff director position. Also, legislative positions are not part of the state personnel system that classifies certain high-level positions as SES or SMS. Therefore, we have concluded that the requester would not be prohibited from representing clients before the legislature during the 2 years after he leaves his present legislative position. The draft opinion is presented for your consideration. I will be glad to answer any questions, as will the requester.
Okay, do we have any questions from the members? Commissioner Ankers?
First, I agree with the opinion, and I think that anybody who's been a staff director of bill drafting deserves a chance at another job. I just questioned the authority of the directory and using the directory as sort of the basis for which we are making some of these factual conclusions about the personnel org chart there. And I wondered whether there was any other kind of source that we might cite to. I'm guessing not, because it's not in there, but that just seemed a little bit like a something produced by the clerk's office for the benefit of public information, more so than an internal personnel document that might be more reliable.
Well, we did look, and we considered that since it is produced by the clerk's office, that it was, pretty official. But we could look for something else, or, look more.
No, I'm not suggesting that. It just seemed like something that I've seen produced sort of for mass use so that people have a better understanding of who does what. And I thought maybe, again, in-house personnel might have something, but I am comfortable with the analysis and the outcome.
Any other questions?
Seeing no other questions, I move for approval of the opinions.
Well, that's where I was fixing to go. Ms. Gillespie, do you have any questions?
As we say at the Capitol, I waive in support of the
Good move. We have a motion by Commissioner Weston in support of the draft, the opinion draft. Do we have a second?
Second.
Seconded by Commissioner Ankers. And is there any discussion on the motion? And all in favor, say aye. Aye. Opposed, say no. By your action, you have approved the opinion by Betsy Daly. Thank you, Ms. Daly. Okay, we are now moving on to consideration of final order acknowledging erroneous firm designation. That is agenda item, say 13-8. No, 8-8. Or no, just 8. Plain old 8. If you think I'm scripted a little bit, well, I am. This matter's become mute and has accordingly been taken off the agenda. Executive Director Doss, would you like to explain this a bit, since we're in public session?
Certainly. This was a situation where a lobbyist erroneously designated his employer as a firm. It makes a difference in lobby registration because firms have to file compensation reports. On our own initiative, our staff figured out that they weren't really a firm, they were just an employer, and we made an effort to try and get that corrected in the computer world so that these people wouldn't get constant reminders to file this report, you're getting a fine because you didn't file the report. But we were unable to get that accomplished, so we were going to ask the commission to sort of proactively waive the fine and announce that this was not applicable to this individual. In the interim, the organization just decided to just file the report, and so it rendered the whole thing moot, and it won't be an issue for the next quarter because it's been corrected in the computer going forward. That's my technical explanation. It's been corrected in the computer is my technical explanation.
Since it's mute, there's no reason for any motion or second.
It's off the agenda.
It's just off the agenda. But I thought it deserved an explanation. So we now turn to item 9 on the agenda, hearings on financial disclosure appeals. And that's item agenda 9. Item 9 on the agenda consists of the appeals of automatic fines under the financial disclosure law. First, we will hear the appeal in which a hearing has been requested. Then we will consider the other appeals. Is there anyone present who has requested a hearing before the commission on a financial disclosure appeal? Is there anybody here for that? Okay. Okay. After we hear from Mr. Gray Schaefer. On the staff recommendation, we will hear from well, we're skipping on past that. There's two that we have. We have FD 15-091. The appellant is Ben Guy. And then there's a second appeal. Okay, yeah, we got a second appeal, FD 12-136, Brian Randall Bess. And then we have FD 15-099, that's on the next page of your agenda, for a Ruiz Nicolas. And we can take all three of those up together at one time, or we can take them separately, whatever the pleasure of the commission is.
Mr. Chair, I would recommend that and move that we adopt the proposed orders in Moss and approve all of them.
Okay, we have a motion to approve all three in Moss. That means all together. We have a second by Commissioner Renzanka. And do we have any discussion on the motion? Seeing none, all in favor say aye. Aye. All opposed say no. By your action, you have approved the motion. Next item on the agenda, 10, financial disclosure extension request. Item 10 on the agenda is a second request for an extension of time in which to file a financial disclosure statement. The law gives the chair the authority to grant extensions of 45 days, but only the commission can grant a longer extension, which is why it's over 45 days and it is on our agenda. A draft order and other materials for this request are in your materials. Bottom line, this gentleman is overseas and in the military. Anybody won't take that one on, good luck. Would you like Mr. Schaefer to explain his recommendation, or do I hear a motion?
I'll just move to grant the extension.
Okay, we have a motion to grant the extension. Is there a second?
Second, and thank you for your service.
Okay, we have a motion by Commissioner Weston and a second by Commissioner Norton, along with a thank you for his services. Norris, excuse me, Commissioner. Any discussion? All in favor, say aye. Aye. Opposed, say no. By your action, you have approved the extension. Okay, we are on final orders on financial disclosure fines where there has been no appeal and no payment. It's agenda item 11. Item 11 on the agenda involves persons whose disclosure statements were filed late or not at all, and who did not timely appeal the assessed fine or even pay the fine. These cases are before you for the adoption of final orders imposing the fines. Are there any questions from the members, or do I hear a motion? Or would anybody like to take up any particular one separately? If that would be the case.
Draft final orders of all individuals listed in number 11.
Okay, we have a motion to adopt by Commissioner Rozanka.
Second.
Second by Commissioner Weston. Is there any discussion on the motion? Seeing none, all in favor say aye. Aye. Opposed say no. By your action, you have approved the motion and the draft to impose the fines. The next item is item 12, reconsideration of collection order and proposed order waiving fine. Item 12 on the agenda is a financial disclosure fine case where, after a final order entered imposing the fine, information was finally presented to us that suggests the individual should not have been fined at all. Are there any questions from the members, or do I have a motion?
Move for approval.
Second.
Commissioner Weston makes a motion for approval, seconded by Commissioner Cox. Any discussion on the motion? Seeing none, all in favor say aye. Aye. Opposed, say no. By your action, you approve the motion. Okay, we have a rule that is being proposed for a change. It's adoption of proposed commission rule. We have notice for today, a public hearing on changes to Rule 34-7, Florida Administrative Code, which is the rule provision that incorporates our complaint form by reference. Ms. Dawes prepared the draft rule change and will explain what it does, and then we'll proceed with the public hearing and deliberation and vote. The purpose of the public hearing, of course, is to allow the commission to hear public comment, evidence, and argument about the proposed changes. Following the public hearing, the commission will decide whether to make any changes in the response to public comments or written materials received, or whether to adopt the rule as noticed. The commission may withdraw a rule in or in part, or make such changes as are supported by the record of the public hearing or any written materials we have received. The commission also may make technical changes which do not affect the substance of the rule, and just adopt it as is. And our Executive Director, Erlinda Dawes, will explain the proposed changes for our consideration and the public's consideration.
Members, as you recall from the last meeting, there was a lot of discussion about our complaint form and information that ought to be provided to complainants. This form has not been updated since 2008, so it was high time. It formerly said, please do not submit video or audio tapes, but said nothing about CDs, DVDs, flash drives. So the primary change there is we added that in. We also asked that complainants not submit more than 15 pages. As I'm sure you're well aware, you're starting to get complaints of 40, 50, 100 pages. That's a lot for you, and it actually kind of slows us down in analyzing the legal sufficiency. That's just a request that we make. We would not reject a complaint because it was more than 15 pages. There was also discussion about the information to be provided to the complainant. Actually, the form that's before you, and I included in the background materials the form that we currently use, but the new form is a little bit more pared down. However, when a person looks for that form online, there's a link right next to it that says more information that provides them, the complainant, with all the information that's attached, I think is Exhibit C, to your background materials. So we tried to keep the form just being the form and the instructions, and then giving the complainants, which we already do, I mean, that information is already out there, all of the information we could think of about how the complaint process works, what can happen, where it can go, etc. So the form itself would be the only thing that you're adopting today. All the rest is backup materials for your information. And we have to adopt our forms as rules pursuant to the Florida Administrative Code. So that's why we're doing this. After I get done, there'll be opportunity for public comment. I'll be happy to answer questions now or later or at any time.
Let me open the public hearing. If anybody's here to speak, they can speak. If not, we'll close it, then we'll come back into the commission. Does that sound okay?
Questions that may dovetail with what the public may say. I don't want us to be in a closed session when we're asking questions of Ms. Dawes.
I'm just opening up a public hearing. That's all I'm doing. For anybody that's here that would like to speak to the rule change. Is anybody here that would like to speak to the rule change? Okay, seeing none, the public hearing is closed. Now, we're into the body of the commission. Is there any discussion, any questions of this rule change that anybody would like to direct to Ms. Dawes?
I do have a question, Ms. Dawes. Under the background materials, section A, exhibit A, page 8, the document starts with jurisdiction of the commission and the procedures followed by the commission. Is that no longer part of the form?
Correct. This is the old form. Exhibit A is the form that we currently use, which I'll call the old form. That language is not included in the new draft. All the draft has is the instructions. However, that is included in where you see C. This is, if you look up the form online, it says the form, you can click on that, and then it says complaint form, and then it says more information. If you click on that, you get all of this, which explains the jurisdiction of commission and how to file a complaint. There's other places online that you can get it, but it's also right there where the form is.
So the complaint form will no longer advise complainants that they may be subject to attorney's fees?
The form itself does not. The information that would accompany it, if they looked online or that we would send to them when we sent the form would.
Okay, is there any other questions of Ms. Doss on the rule change?
Just several.
Commissioner Weston?
I guess dealing with the attorney's fee, and so just go over how it would envision it working with the new process again, as we'll be removing that attorney's fee provision on the complaint form.
The way we worked on it was this way. Initially, we delved into putting all the information that a complainant would want on the form itself. That led to a long and somewhat, I thought, intimidating form for complainants. So then we thought about, if you have a form, what you're usually looking at is the form and the instructions for completing the form. There's a lot of information complainants need to know, or would want to know. Once I fill out this form, then what happens, what's the review process, and getting to the end of the process, do I have exposure to attorney's fees? At the last meeting, we talked about including information that the attorney's fees decision could be appealed to the District Court of Appeals. All of that information is information I think any responsible complainant would want to know, but it's not an instruction for filling out the form. So since the form and the more information are right there next to each other online, the complainant has that at his fingertips. When we send out the form, we can easily send out the additional information with it as well. But in terms of just, this is a form and this is how to complete it, we kind of limited ourselves to that. We can put as much information attached to the form as you would want to have, but, you know, as I said, some on our staff commented that that seemed like it would discourage people from filing complaints.
Right. Well, in the number of years that I've been sitting on the commission, there has always been the issue, not always been the issue, but many times the attorney's fee issue come up, and we were just trying to figure out how to handle it, whether or not, I mean, there's various issues, but it seems to me, and I may be speaking out of school, and I'm not trying to make our lives more difficult, but then again, I think it's important to know for these individuals who want to file a complaint, to know that they may very well be subject to attorney's fees if, in fact, the standard is if it's malicious and intent to harm the party. And I think that's almost critical. It's in my view now, and I don't know how to resolve it other than possibly making sure that on this form, you maybe not have to put all the lingo that we've had in the prior, but make a notation that they should be reading X, because if they don't read it, I just don't. I think we need to put some notation, if it's not there, that they need to go read this before they fill out the form. That way you don't have to have it there, but it's incumbent upon them. Before filing a complaint, please see X something, particularly whatever it is. So at least they can be on notice that that's occurring. At least that's my thinking, at least at the moment. Obviously, as we discuss it, it can be refined. Secondly, as most of everybody knows, well, if you're a lawyer, you know this, but if you're not, it may come as a surprise that we are trying to limit. We are trying to limit the number of pages, and most courts do, in certain circumstances, limit the page limitation to briefs and memos a lot of times. So this is not necessarily unusual. But with regard to that, I think we should make it clear that more than 15 pages, including exhibits. That way, it's clear if that's what we want to do. But those are some of the questions and concerns, if you will, that I currently. Thank you.
Commissioner Weston, was there like a motion coming out of that somehow, or just an observation?
Well-
And I ask that in all sincerity.
Oh, no. I don't want to make a motion until I hear from the other colleagues, because
Okay.
I want to make sure that it's something, if it's not practical, it's not practical, but if it's something that we can work with, but I'd like to hear what other people think. But that's my initial thinking. So it's not in the form of motion quite yet.
Okay.
But I think it need to be refined possibly.
Perhaps one in waiting. Commissioner Brady,
I'm just gonna-
you're recognized.
When you go to the website just says, here's a click that says go to the form? Because I think that what was suggested was some language that really says, prior to filing a complaint, you should, clearly read the attached material beyond the instructions.
Or I have read.
Or I have read the material before the instructions, because the truth of the matter is, every now and then, we go look at a form, we fill the form out, and then we get a weird email from somebody thanking us for having purchased their service when we thought we were simply doing something for free. But I think some language that really made it very clear to people that they should have an understanding of the process prior to submitting a complaint would be helpful.
If I may, I don't think we have statutory authority to force anyone to read the additional information. On page 9 of your materials is one place on the website where you can get the form. And as you see where it says Form 50, Complaint Form, more information. Now, we can enhance that language, I think, to say, please read this information. We can put when we mail out the form, we can include that information with it, and we can put on the form something that says, please read the additional information. But I do not think that we can require people to read it or demand that they certify that they have read it.
I think I had Commissioner Norris first, and then Commissioner Cox will be follow-up.
Thank you, Mr. Chairman. I concur with Commissioner Weston regarding some effort within the form to drive the viewer to the instructions, and I appreciate what our executive director says about maybe you can't seek an acknowledgement or a certification, but I think it would be a good idea that the form itself reaffirm or reiterate, check out the instructions. And I think most of the federal government forms that you see, like with the IRS and things like that, tend to do that. And I know I'm guilty of trying to fill them out without reading the instructions repeatedly myself. So I think that would be good. I somewhat question the number of pages at 15, and related to that, I'm offering as an inquiry of our executive director and the staff as to whether or not within those instructions, do you deem it at all, or did you consider, or is it, in your opinion, advisable to perhaps offer somewhat of a suggested format of the complaint materials that are presented, in the sense that typically, I think, we're dealing with these complaints from lay people, but it is a formal legal process, and if you're like the appellate court and you're designating, it comes on this kind of paper and this margin and this size type and all that sort of thing, which on one hand is somewhat burdensome. I dare to say that here in the First District Court of Appeal. It's somewhat burdensome, but on the other hand, it also makes the document better and more. It improves it. It makes it easier for our staff to deal with it, to read it, to see it, and understand exactly what's going on. I would probably increase the number of pages a little bit, particularly if we had a suggested format that asked for this to be in a double space type or something along those lines for it. And so I just offer it as a thought and interested in our executive director, who's much more experienced on these matters than I, and what your thoughts are with regard to that, please.
Would you like to hear her answer before we go to our next commissioner? Would you like to answer his?
That's at the chair's discretion, sir.
Through
Thank
the
you, I
chair,
appreciate that.
we did look at that. It would make our lives much easier if we did not get little tiny handwriting and single space. On the other hand, I'm not sure that we have statutory authority to limit people to a particular format or type space. And B, I think that would be, as these are lay people, that would be a significant burden on some of them who may have valid complaints, but who don't have a typewriter or can't put it. What we do and what we ask people to do when they call us is explain what it is you think the person did that violated the ethics laws. Most of the people who file complaints don't fully understand what is an ethics law and what's just something that doesn't seem right to them. That's fine. So we just ask them to explain as clearly and briefly as they can what it is they think that the person did that violated the code of ethics. So, and I don't know exactly how else we could format that for them.
Mr. Chairman, if I may just briefly respond. Right, I absolutely appreciate that we don't have authority to mandate something, and I offer the consideration as a suggested format, and really what and I know I spoke of how the DCAs moderate that, but what I'm really trying to get at is sort of the like a couple of bullet points that gives that layperson the essence of what it is important for the commission to receive with respect to facts or direction toward documents. And you don't have to include them, but reference them in a manner like this. It shortens the information they provide, perhaps. I'm happy to receive, that we would receive handwritten ones and all that. So it's not trying to create burdens, just trying to help them help the commission and the commission staff.
Our goal is to do whatever you want. So, I think the comments I'm hearing suggest that we need to go back to the drawing board on this, and so I'll bring it back at the next meeting.
Before we're done with that, Commissioner Cox has had his hand patiently waiting to be called upon. Commissioner Cox?
Thank you, Mr. Chairman. I don't believe the form goes far enough. I would like to see a series of acknowledgments of some items on the form that the complainant needs to initial, that they understand that. And give you an example, the fact of the confidentiality. I don't think the form or the instructions spell out specifically that, as I read this thing as a layperson, I still come to the conclusion that the confidentiality lies with the commission, but it should be spelled out that the complainant as well should be held to that, even though I realize that there's the case law may be opposed to that, but I think that is the reasonable expectation. So I think there should be something there. The attorney fee issue, that if they are making a malicious complaint, that they could be held for attorney's fees. I think that needs to be an area that, again, they initial, that they understand the process of the investigation, and that they don't need to make their full case in this complaint, that, the investigator, if it's deemed to be investigated by the executive director, that the investigator will contact them, gather evidence, and put it into the official report back to the commission. And also, I think the fact that they are entitled to legal counsel, I think that ought to be another area that they initial, saying that they understand that. So, looking at it from a layperson, I'd like to see it a little bit more geared towards what a layperson would do.
Unless I see any more, are you through, Commissioner Cox?
Well, I'd also like to see something in there that lays out what the process is if it does come to a hearing, so that they can understand the fact that they don't have a voice at the hearing. I'm not sure if, well, since we're just on general rulemaking, I'll bring this up.
We're on specific rulemaking, but you can go into general a little bit if you want to.
Well, I'm going to bring back up the issue of the complainant's involvement in this process, and I would like for the commission at this meeting to make it part of this official meeting, the letter that we received that was dated June 4, 2016, from a Camille Caldwell, who was a complainant in a hearing in a matter that we heard. And if the commissioners have not read this letter, I think you need to read it, because it's written by a very eloquent individual who is obviously well educated, and it's her perception of how this commission handles complaints that people make. And so, I mean, I have copies here. I'd like to pass it down to you and ask it that you receive and file it and make it part of this official meeting. And also, a letter dated June 14th from our executive director. Did a great job answering the letter, and she did a wonderful job in that. I'd also like to see that be made part of the record as well. But at the end of the day, I just believe that, you know, when you have several complainants address the commission, being critical of the commission, how the complaints are handled, I think it has to give you pause to say, are we serving the public correctly? The legal minds may say, oh, absolutely we are, but, you know, perception is reality many times. And this complainant, you know, when you read that there seems to, this is a quote, there seems to be an overall condescending air of disgust for the public who risk and invest their time offering their complaints. When a complainant writes that, doesn't that give you pause that maybe we're not doing things completely right? Maybe by the letter of the law it seems to be correct, but where's the common sense? So as we're talking about rulemaking, I'd like to see us revisit this issue of how complainants can be involved in this process. You really need to take a look at this and really ask yourself a question. Are we serving the public? And I really don't think that we are serving the public to its fullness in how we treat the complainants during hearings.
Okay, Commissioner Cox, I appreciate your passion on that. I agreed with you, but we went down in flames. So I'm not sure how quickly we're going to be able to bring that back up and rehash that, but I do think your point is very well taken. By a vote of something like 7-2. Anyhow, I don't think we're going to be taking this up. Perhaps defer it. Ms. Doss, or do you want to have anything else to say?
I'd kind of like to get some guidance as to what you all, I've heard Commissioner Weston's suggestion about please read the more information. Commissioner Cox, you seem to kind of feel like all the information should be included in the form, and others had various other suggestions. So if if I could get some guidance as to what you all want in the form, I can come up with a better draft for you at the next meeting.
Well,
He was
Commissioner
first.
Brady, you would be next since Commissioner Cox just spoke, so you're recognized.
The suggestion that there be a assertion, we don't believe there's any legal foundation for doing that in terms of processing a complaint.
That's correct. I don't think we can require the complainants to verify that they've read anything or that they agree with anything. All we can do is put it on the form. They can read it or not. Judging from the financial disclosure forms that we receive, mostly people are not reading what's on the form, but that's a digression.
Just saying, right? Just saying. Okay. Commissioner Cox, did you had your hand up, so was it up all the way or halfway up? Or?
It's down right now.
Well, if I may, Mr. Chair.
Mr. West and I would love for you to try to condense this and give Ms. Doss what her
Well-
marching orders would be on the commission's comments this morning. I think that's what she's looking for, and that's what she needs.
Right. Well, let's start with the page limitation, because I know Commissioner Norris mentioned that he was thinking that that may not be sufficient. I think we probably want to deal with that issue first. Let's do one at a time, possibly. And are we comfortable with 15 pages? Or not? Do you want to make it 20 pages? And I would just say that if you have an article that you would like to attach, in most instances, the article is not going to be more than a couple of pages, 3 pages, whatever. I don't know, unless they're providing a part of the book. And it will require them to, at least it would suggest that they would kind of cull it down and pull out the most essential things. And if we are as a commission or investigators or tuned towards a certain, reference, then they can then go further and look more. And so I suspect then that's what we probably want to do, is try to figure out the page limitation issue first, and then maybe deal with these other things about the critical areas of legal counsel, attorney's fees, and all this other stuff. That's my suggestion.
Any other suggestions? Council, or, Commissioner Norris?
Another comment. Commissioner Weston, your earlier comment regarding making it very clear that the attachments, exhibits, whatever you'd like to call them, are not part of whatever that page number is, whether it's 15 or 20 or, what some other number. I don't know what the right answer is for that number. But I think that's very important, that it be clear that the supplemental supporting documentation is not part of the 15. I think 15 is in essence their statement of facts and any type of advocacy they want to make for their own position. And then I also appreciate the comments of Commissioner Cox, and I'll just say, and as one who voted on the prevailing side of the efforts regarding the folks coming before the commission, I don't consider that an absolutely closed issue at all. I think that everyone on the commission has expressed that we're looking for the right mousetrap on exactly how to do this, and that maybe the existing one needs some improvement. Now, I don't know that I don't go as far as like throw the baby out of the bathwater with regard to what has been going on for the past 20-something years, but I'm going to foreclose, have it in my mind, think that the commission has completely foreclosed even that presentation. I'm interested in more information from our staff on how something like that would work if it were to be done. I was making inquiries of our staff last night about that very issue. So I think this is a great start here. I think this is an improvement on what we presently have as is presented, and I appreciate those efforts. Again, I'm just interested in seeing if we can find that just right niche for it and as to what it has, but try to drive the folks to presenting their information in a way that helps our staff to cull through it, to understand it, and also that they receive the appropriate notices, if you will, right up front as to what they're getting themselves into when they sign one of these. And that's, I think, extremely important and needs to be in there. Now, I agree with our executive director that all of that can't be in the form. I think that the form is the form, and then these instructions and notices and what have you are something that we cannot necessarily guarantee that they'll read, but certainly, from my perspective, our job is to do everything we can to help them understand in a nice, clear, concise manner exactly what's going on here and what they need to think about.
Mr. Chair.
Commissioner Weston.
Oh, and I'll just be clear. I wasn't making a suggestion one way or the other, but I was, as far as the 15 pages, I wanted the commission to clearly state one way or the other whether or not it will include 15-page attachments or not. Because right now it's not, to me, I guess you can interpret either way. I mean,
If I may, Mr. Chair, and my thought on that, again, I just thought it was a very good point, because my thought on that is that the supporting documentation very well could take up your entire 15 pages very easily. And so that's why my thinking is it should not be part of whatever the number is, 15 or otherwise.
If I may.
Yes, ma'am.
I don't think we can force anybody into a page limit. We asked them on here, on the form, to limit it to 15 pages, but we would not reject a complaint that was of more than 15 pages. Quite often the supporting documentation is copies of our own statutes and things of that nature. So we can leave off a page limitation entirely. It doesn't have any page limitation on it now, or we can say 15 pages minus, usually it's the supporting documentation that comprises the 85 pages, and the narrative. Sometimes there is no narrative. Sometimes it's 50 pages of newspaper articles, minutes of meetings, and we're left to cull through that and try and figure out what the person is actually complaining about. But yeah, we would not reject a complaint because it was more than 15 pages. So we can do that either way. We'll figure out something on the page issue.
Mr. Weston, did you have I thought I saw your hand inch up a little bit.
I think we all understand the concerns, and I don't want to beat the proverbial dead horse.
Well, as chair, I think my main job is to try to run an orderly meeting and not to get involved in much discussion, but I am going to make one observation. As much as I agree with Commissioner Cox on allowing the complainant the ability to speak, I also think we need to be very careful, though, in how we word, if we word, in this complaint form that they will not be allowed to speak, as to not send the wrong message of the attitude of this commission. So however you word that, that's why you're executive director. I'm sure you'll wordsmith that properly. But we don't want to just say, and by the way, you don't get to speak. We might want to wordsmith that a little bit in a way that just explains the process and doesn't convey an attitude of we don't want to hear from the complainant. And the other thing that, being a non-lawyer, is the KISS principle, keep it simple.
simple, we'll just say that. And, because complainants, my son made a very interesting observation as we drove here today. And as you come down the highway, you see this impressive building, and he said, gosh, no wonder the legal system's so backed up. I mean, this is the Court of Appeals. This is just one of the Court of Appeals. Look at the size of this place, you know. So it's just a mere complication of the legalities, and we're just dealing with people that are trying to make complaints. And I think that's what our director is trying to do, is make it simple, and we want to make it friendly. Commissioner Weston, did you have another comment? Anybody, any other comments? Commissioner Cox?
I appreciate your wanting to keep it simple. The vast majority of the complaints that are received are filed by lay people. And that's my overarching comment, is that these forms should be being able to be understood by lay people. I know that's hard for lawyers to do, but that's why I made a suggestion that simple statements, and that they initial to acknowledge that they understand these simple statements should be included on the form. But the lawyers are telling me we can't do that, and
I'll be happy to appoint you as a subcommittee of one if you'd like to work on this.
I'd be more than happy, but I have a feeling it'd be a wasted time, because I don't think it would be well received, to be quite honest with you.
Well, I think it would be well received. I'm not sure it would be agreed with totally, but it would be well received.
You know, I will make a comment that the complainant needs to understand that they are not a party in the hearing. They don't understand that, because a reasonable person would think you get your chance to be heard, but that's not the way we operate. And unfortunately, it appears that one of the driving forces of that is because we want to keep our meetings as brief as possible, which is pretty sad.
Commissioner Cox, let me just make one more observation. And again, you and I are on the same side, so I feel like I could say this.
Yeah, absolutely.
Okay. But they are a party to the complaint, because they get to make their case to our investigators. And then the investigators then turn over that complaint to the advocates. So they are a party to it. They just don't get to speak at the public hearing for reasons that could be argued both ways. And we might take that argument up after the holidays, whether I'm here or not. But I think we need to move on, unless Ms. Doss has any need for more direction. Let's move on with this, Commissioner Brady.
Just a point of clarification for me. At the conclusion of our deliberation, when we make a decision, is all of that information still contained as confidential?
Through the chair, no, Commissioner Brady. Everything becomes public as soon as the order is rendered as the probable cause.
So, I mean, hypothetically, we could have someone sit down with a complainant who said, I don't understand why the outcome I thought would happen, to actually go through potentially some of the points of law and information in the investigation, which would say, yeah, we may not think this is the best way the law is written, but this is how it's written. And it might be helpful to people to understand that there really are parameters in which we all operate.
Through the chair, that happens routinely. A lot
Okay.
of times after the probable cause, you'll see the investigator walk out with the complainant. They're explaining what's happened, what happens next. Also, the complainants often call the complaint coordinator to see where things are, and once the complaint, if it's being prosecuted, oftentimes the complainant is a witness in the case, and so they'll be contacted by the advocate. In addition to that, a lot of times before filing a complaint, people call the office and they'll talk to Carrie about, what the law says, what happens, et cetera. if you, Mr. Chair, if you want to appoint Commissioner Cox as a committee of one, I'll be happy to work with him or any other member on drafting this form. The staff just wants the form to be what you want it.
Commissioner Ankers.
I was just going to speak to that issue that because Ms. Doss is going to have to do some revisions to bring this back for our review, I would be very open to Commissioner Cox making his observations on potential modifications prior to it coming back to us without revisiting the issue of the complainant's right to speak. But I do think we value very much your perception of the communications that we are providing to the public, the readability of that, the informational value of that, and I would actually find it very valuable for you to make that contribution.
Thank you.
I don't think
That'll
we
teach
actually
me.
need to appoint a committee, but I perhaps we do, but I think that it'd be a long haul for him to drive up here to talk with
called a
Ms. Foss,
computer.
but perhaps
Yeah, I don't need to do that.
conference call.
Emails are wonderful.
Might be in order. I'm not sure you want to put it in email, but I'm just saying.
doesn't care.
Been hearing a lot about emails lately, but anyway, I think that's an excellent suggestion, Commissioner Ankers, and I would like Commissioner Cox, he feels very strongly about this, and I do too. And so I think we're going to have a better product if you can work with our executive director on this when she brings it back to our next meeting, if it is at our next meeting. And does anybody have a problem with that? Any issues? And anybody else that wants to call? We just can't have two people at the same time because of the sunshine law, talking to Lindy about it. But if somebody else wants to make a call to Ms. Doss, I know she would be anxious to hear from you as she tries to put together the final product. If you have a comment.
If I may, Mr. Chair, I would just say that, I would welcome receiving this information earlier in advance of our next meeting as we go, and perhaps, obviously, it can only be direct between individual members and the executive director, but to have that opportunity to review it in advance of the meeting and perhaps make some direct response to it.
I can send any of you that want it drafts, and you can send me whatever you want. What I can't do, what I won't be able to do, is if Commissioner Rosanka has a revision that says, take this out,
Right.
I won't be able to say, no, Commissioner Weston wants that left in.
Right.
So that may result in your receiving multiple, I'm not sure how we would do that as a rule, maybe a rule development hearing where you could have multiple copies, I guess, of a document from which to select.
I think that this is where I think keeps us out of trouble, if I might make the suggestion. Anybody that has a concern, an observation, an addition, a deletion to what has been proposed to us today, to make that phone call directly to Ms. Doss, and then let's not have any communications beyond our next meeting. I just think that if we start shooting emails back and forth, we could trip up, and that's, in the law of unintended consequences could come and grab us in the wrong place. So that would be my recommendation.
One more comment, if I may.
Commissioner Rosanka?
It may be that we cannot allow we can't force the complainant to acknowledge, but if it's on the form, there's a belief that they've read it. So that's why I'm concerned about taking out the attorney's fees, the confidentiality. Procedures followed by the commission, to me, I think that's beyond the scope of what needs to be in the instructions of the form. But I think it's very important that at least if it's there and maybe some instructions, that we can presume that they've read it. Whereas if they have to go to another, I don't blink lots of times when I'm filling out forms, which is maybe why the financial disclosure form is so difficult for me to follow. But I just think it does need to be clear. I think it needs to be on the form. And just looking at this attorney's fee provision, it's 5 lines and it's 1 sentence. So I think we need to shorten up some of the, make it a little clearer. I mean, it's very long and confusing. I think it should be in the form as opposed to going to a form.
just so
No.
can kind of be clear on what I'm going to be doing after the meeting. I feel what I'm hearing is kind of be working with Commissioner Cox. My effort will be to be more inclusive of information rather than less inclusive. And the commission can take out whatever it chooses. Commissioner Cox will work with me to get the wordsmithing right so that it is as user-friendly as possible. And then we'll come back at the next meeting. If any of you have individual suggestions, feel free to send them to me. Email is fine as long as you don't email each other. And also that way it makes a nice transparent record for anybody who's interested in the public record of what everybody's comments were. And then Commissioner Cox and I will work and bring back a new product at the next meeting.
Okay, that sounds acceptable. Okay, very good. That will be deferred until we're ready to take it up again. Before I move to the next report, I have been remiss in not allowing Commissioner Ankers to recognize perhaps a family member that she has with her. So,
Thank you. I might have to wake him up on the back. Samuel Ankers Medina is my son. He's 14 years old. This is his second visit to the Ethics Commission and his mandatory summer civics lesson.
we had a chance, our family had a chance to meet with him last night, and he got to hear how the old Capitol was really saved.
It's a very valuable tour in Florida history. Thank you, Chairman Carlucci. And your
Okay,
beautiful
Sam,
family.
nice to have you here, my boy. Okay, now we're going to the consideration of the 2017 meeting schedule. Anybody want to try to move one of those around? Everybody like the schedule that we have for the year 2017? Any discussion on it? Any motion?
Move to approve it.
Motion to accept it?
Move to adopt as presented.
A motion and a second motion by Commissioner Weston to accept it, second by Dr. Brady. Is there any discussion? All in favor say aye. Aye. Opposed say no. By your action, you have approved the 2017 schedule. And now we're on reports. As the chair, I don't have a report to give, except I'm just glad to be here. Our executive director, do you have a report that you would like to?
Just with respect to litigation in the Rivera appeal, as the commission, the first DCA issued its order a couple of weeks ago, upholding the commission's final order. Mr. Rivera has filed a request for rehearing and to certify a question of great importance to the Florida Supreme Court. That will be responded to probably next week. In the Al Hadid versus Commission on Ethics case, oral argument has been set for September 17th. I believe those are streamed online, so if anybody wants to watch that, they can. And the governor has issued, in the penalty department, the governor has issued an executive order imposing the penalty in the Manfrey case. And that's all I have.
Okay. I do have one comment I meant to bring up. I hope this is in order. If it's not, Ms. Doss, you let me know. At our next meeting, we will take up our annual list of reforms and requests of the delegation or of the legislature. And we have to do that by law every year. And so I know that I have one that I have mentioned to Ms. Doss that I would like to be considered. And I would encourage anybody here that if you have some reform that you think would be well for the commission to consider, to also direct that to Ms. Doss before our next meeting, so we're not coming up with stuff left and right at the next meeting in an unorderly fashion. And so I got to tell you, every year is an opportunity here. This is an opportunity. We don't always get what we want from the legislature. But you have not if you ask not. And so if you have something that you think is important, then let's ask it, let's discuss it, and let's take it over. And as long as I'm chair, whether it be just today, or 2 weeks, or however long, we will have, I will pledge my leverage as chair to push for that. And if I'm not here, then our vice chair would take over, and hopefully she would leverage her abilities. Because when you're in leadership, you only get one chance at something like this. Maybe some shorter than others, you don't know. But if you're going to take leadership, you can either grab the steering wheel and just control the boat, or you can try to do something with that leadership and to leverage it for the betterment of the state of Florida, for the people of the state of Florida, for good government. And so I urge y'all to be thinking along those lines, and if you have something, get those to Ms. Doss so we might take those up at our next meeting. Is there anything else that I might be? Okay, the public session is now adjourned. We'll meet back in about 15 minutes, which usually translates about 20 minutes.